I got the notification that the recording started.
Perfect. So hello to everyone who is coming in. We'll just give it a few more moments and to wait to see who arrives. Great. So hello everyone, and welcome to this next and the final panel of today in the Vulnerability Across Disciplines conference. It's a real pleasure to be here, and I just want to say thank you so much to the conference organisers for inviting me to be part of this as a chair, in particular Dr. Tim Dodsworth, who extended a kind invitation to me as a then current colleague at the University of Exeter. We miss you, Tim. So we have three fantastic speakers in this panel. What I will do is I will briefly introduce each of our speakers, go through some of the housekeeping before then handing over to the three speakers in turn, and we'll then have 15 minutes approximately for questions, answer and further discussion at the end of the session. So the first thing I do just want to say is just to remind everyone that this session is being recorded, so please be alert to that, and please do try to remain on mute unless otherwise requested, so please just be alert to that too. Our panel is going to be 60 minutes long, so we have three speakers, each will be speaking for 15 minutes, and then as I say, 15 minutes at the end for question and answer. The chat will be, as I understand, open, so if anyone has any questions that they would like to raise for the Q&A part, please do feel free to add those to the chat throughout the speakers. We will then address those in the Q&A session. And when we get to the Q&A session, I'll go over this again, but if anyone would like to verbally ask their question or make their comment, then they're very welcome to do so by using the hand up function on Zoom, and then I'll invite you to unmute. So to our three speakers, first of all, we will be hearing from Dr. Eleni Kaprou, who is based at Brunel University. Elena is a lecturer in commercial law and has been since July 2018. Prior to that, Eleni was a postdoc researcher at Cardiff University in an ERC project on EU law and governance. She received her PhD in 2018, which received the 2018 DJ Harris Award for Best Thesis in Law from the University of Nottingham. Congratulations, Eleni. And Eleni's research interests lay in European private law with a focus on vulnerable subjects. Our second speaker will be Dr. Andrew Hutcherson. Dr. Hutcherson is an associate professor in the Department of Commercial Law at the University of Cape Town. Andrew teaches agency, insurance, secured transactions, insolvency and consumer credit law to LLB and commerce students. His recent research has included context-focused elements aimed particularly at inclusion and transformation. For example, an empirical study of community savings and credit clubs in Cape Town. This has fed into an interest in the law and practices connected with the low-income financial sector. Dr. Hutcherson is also interested in how modern forms of commercial activity translate into living Indigenous norms. And then our third speaker will be Professor Alexander Kirpichev. Alexander Kirpichev is head of the Business and Corporate Law Department and a professor at the Russian State University of Justice under the Supreme Court of the Russian Federation. His principal research interests are in the sphere of contract law, especially in untypical contractual relations. The key method of Alexander's research is the comparative analysis of legal doctrines across different countries. Alexander defended his PhD in 2011 with a thesis titled Local Contracts in the Civil Law of the Russian Federation, and defended his LLD in 2019 titled Business-to-Business Contracts of the Public Sector. So once again, it's a pleasure to welcome all three of our speakers to this final panel of today. First, it's my pleasure to hand over to Dr. Eleni Kaprou, who will be speaking on the topic of transforming the EU's vulnerable consumer, the role of resilience. Over to you.
Thank you. Okay, now you can hear me. Okay, so thank you, Ben, and sorry for the mute. And many thanks also to the team and to Christine for organizing the conference and for the invitation. It's been really interesting to hear all the speakers and their discussion of different perspectives on vulnerability. Obviously, my research is more on consumer vulnerability, and as it is in the EU law context, so I'll be focusing on that. Let me start with how I view consumer vulnerability in my research. It is a conceptualization that is influenced by transformative consumer research on the one hand, and of course by theories like vulnerability theory by Martha Feynman, and the idea that vulnerability is universal and it is inherent to the human condition. Going back to the marketing perspective, there is the existence between, or the categorization of vulnerability as class-based vulnerability, which means that some categories of consumers are viewed as vulnerable based on their characteristic, and state-based approach to vulnerability, which means that vulnerability is a state, a transient state that anyone can experience at any point in time. And I would say that these kind of theories are quite familiar to everyone within law and consumer law that's working on vulnerability. However, we see a gap between the views that are prevalent in the academic community and how vulnerability is being used in legal documents, in hard laws, and in European directives. And I'll be talking more about that next. So I view the vulnerable consumer as one who experiences a heightened susceptibility to harm in the marketplace as a result of actions or omissions of the trader. So a vulnerable consumer is not only vulnerable based on personal characteristics, it is an interaction of market conditions and personal characteristics that creates this heightened susceptibility to harm. And I say heightened susceptibility to harm because to an extent, all consumers are in a weaker position vis-a-vis the trader. This is the starting point of consumer law. So based on that, a vulnerable consumer is more vulnerable than just the consumer in a way. And some of the key dimensions for conceptualizing vulnerability in this context are the likelihood the consumer has to suffer detriment. As we said, a vulnerable consumer has a heightened detriment. For example, a poor consumer suffers greater detriment when he enters into debt compared to a kind of more well-off, financially solvent consumer. When you take into account things like how familiar, what is the knowledge that the consumer has in a specific market? Do they have expert knowledge? They have experience in that market? Or is it potentially the first of one of few times they will make such purchases, like, for example, to take out a mortgage? And what are the personal characteristics of the consumer? Physical, what are their capabilities? What defines them in the eyes of the trader? And the freedom of choice, referring to kind of competition around vulnerability. Do they have a lot of choices in the market? Do they have alternatives? Because a lack of alternative will definitely lead to vulnerability of the consumer. And moving on to resilience. Resilience is the yin to the yang of vulnerability. It's the counterpart. So any factors that increase resilience will decrease vulnerability. And I borrow also a framework as championed by Kirby on how to conceptualize resilience. And resilience can be influenced by physical assets, such as levels of indebtedness, how much assets do you own, human assets like education and social assets, such as family, membership in communities, let's say in trade unions or state systems, and even environmental assets, like where are you located? What access do you have to essential services? And what it is envisioned for the role of resilience in the vulnerable consumer context in the EU is that it will allow for greater nuance and flexibility for regulators in order to be able to judge cases more on an individual basis, rather than simply place consumers into boxes and categories, to be able to have greater flexibility in taking into account their specific circumstances in order to reach an outcome as to their levels of vulnerability. What it is not envisioned to do is to be used by regulators or even by traders to argue that certain categories are not vulnerable or not in need of additional protection. Resilience is envisioned as coming not only from personal characteristics of each consumer, but also coming from assistance that they receive from the state, from the systems that surround them, and taking into account a multitude of factors. Leaving that theoretical framework behind, I'll move on to discuss what are the legal definitions we have in the EU for vulnerable consumer. And the number one definition, it was also mentioned a couple of panels ago, is the one that we see in the Unfair Commercial Practices Directive, which is the only one out of the big EU consumer directives that incorporates the concept of the vulnerable consumer. And the vulnerable consumer in that context needs to refer to a clearly identifiable group of consumers. They are particularly vulnerable to a practice or a product because of this specific list of reasons: mental or physical infirmity, age, or credulity, and the trader must be able to foresee their vulnerability. And again, these criteria have been criticized as being very narrow, as reflecting a class-based view of vulnerability that is now not so prevalent, and for leaving out a lot of other categories of consumers that may potentially be found in a vulnerable position, and most notably poor consumers, over-indebted consumers, etc. And we do have, of course, the credulity criteria, which is unclear as to what does it mean, how do we use it. And generally speaking, the definition has not been as useful and successful in practice as one would think. So there are certain weaknesses and issues there. Now, if you are not so familiar with what is going on in EU consumer law, there was recently a wave of reforms in these major directives, including the Unfair Commercial Practices Directive that I just mentioned. And there was this modernization directive brought on that brought changes to all of them, exactly to modernize them for the new age, for the digital age, and to make sure they are more effective in their enforcement. So there was a chance there to step in and address the issues that related to vulnerability, but that was not done. So they did not touch the vulnerable consumer definition, and they did not seem willing to do so. And that is a lost opportunity, because as now we have had already a kind of reform on that, are we going to have a new one soon enough? But as we will see, there are certain plans of making some amendments to that directive and to this vulnerable consumer definition, which is the main one that we have in EU consumer law. I'll take a look to some recent developments that we've had. So in 2020, the European Commission of Ursula von der Leyen issued the EU Commission Consumer Agenda, which is called Strengthening Consumer Resilience for Sustainable Recovery. And it's the first time, or one of the few times, that we see resilience being stressed by the European Commission. And of course, the resilience here is related to the resilience that consumers are going to show in relation to the pandemic. And some of the issues that are highlighted in that document are consumers falling prey to scams, like fake cures because of risk associated with the pandemic. And these are risks that are not so easy to tackle, in my opinion, because they do not just reflect that I did not know that this product would work. We do see that consumers may ignore reliable information from state organizations or big scientific unions, and they may instead choose to rely on information that is not verifiable and has proven to be false. So that is, on the one hand, the Commission cares, what do we do about the pandemic? How do we make our consumers more resilient? And the other aspect of vulnerability that they highlight is digital vulnerability, especially things like algorithmic discrimination. So how do we improve digital literacy? How do we ensure that older consumers or disabled consumers benefit and receive assistance in the digital environment? How do we protect children online? And some of these answers are related to information and to education. So we need to kind of provide assisted technologies, and that is what is going to increase resilience. We are going to inform consumers, and we are going to work with all the key stakeholders, such as the online platforms, the business associations, the advertisers, the consumer organizations, and we will all work together to improve the situation. And we see once again that the Commission is kind of getting caught up by the recent developments and by reality. So in the same way that the European Commission ignored for a very long time the enforcement of consumer law issue until there was Dieselgate and they were forced to take action, we might see something similar happening with vulnerability and resilience. So that's an issue that they were not willing to actually broaden the concept of vulnerability, but they may be more willing to do so because of developments such as the pandemic, bringing vulnerability to the forefront of the political issues that they have to face. And I don't think it's adequate to say that this is an issue that will be resolved only by informational campaigns or only by cooperation between enforcers or between traders and the state. It's something that, as we have seen, because we don't have the right legislative framework, requires also reform in the law. I'm conscious of the time, so I'm going to speed up through looking into the two new proposals that we have for the digital environment. So the digital environment is a priority for the Commission. We see some new pieces of legislation being brought to regulate digital environment and digital marketplace. And how do these newer proposals that were brought in 2020, how do they treat vulnerability? Do they offer a more expansive view than what we saw previously in the Unfair Commercial Practice Directive, which was passed down in 2005? So we have the Digital Services Act proposal, and there we see that a definition of vulnerability that includes different criteria. So people could be vulnerable in their use of online service because of gender, race, ethnic origin, religion, disability, age, or sexual orientation. So definitely we see broadening of the criteria, even though we don't see something like universality of vulnerability. And we do see how they want a kind of like preventive approach that anything that may be considered to be high risk for these groups should be removed by the online system, from the online systems, and that there should be moderation tools to ensure that these vulnerable or disadvantaged groups are able to effectively use online services. And I'll just comment on another online proposal, which is the Artificial Intelligence Act proposed regulation. And that is one of like the flagship interventions and legislative proposals for the new Commission. And it is viewed as the one that is going to be the most effective in addressing digital vulnerability. And there we see different categories of vulnerable consumers being highlighted, apart from the classic that we mentioned so far. So consumers that are vulnerable to their age, physical or mental infirmity, as this is a broader that reflects artificial intelligence systems, not only in B2C, business to consumer transactions, but more broadly also in the state. So we see natural persons applying for or receiving public assistance, benefits and services from public authorities. So they are in a vulnerable position vis-a-vis the responsible authorities for granting their applications, and the artificial intelligence systems that may be assisting or determining whether they will have access to such benefits need to be regulated and controlled and are considered to be high-risk systems. for that directive. Similarly, artificial intelligence systems that are used in migration, asylum, or border control, they also are high-risk systems because they affect particularly vulnerable populations, specifically asylum seekers that depend on the outcome of the actions, and they must not offend their rights to free movement, non-discrimination, protection of private life and personal data.
Amy, just if you could conclude.
Yes, I will conclude. So what I want to say for the end is that my suggestion would be that we do need a better framework for vulnerability in EU law, and the way to do that would be to have an EU-wide definition for vulnerable consumers that would reflect certain dimensions of vulnerability. And that would be also to avoid having a divide between digital and physical environment, and having an EU-wide definition that would also focus on a state-based approach of vulnerability would not stop legislators from also having sectoral legislation that would qualify this definition further. And that's it. And sorry for going a tiny bit over. Thank you so much.
No worries at all. Thank you very much, Eleni. That was terrific. As I said before, if anyone's got any questions for Eleni, if you could hold those for the moment and or write them in the chat, we'll come to those towards the end. So now I hand over to Dr. Andrew Hutcherson, and Andrew will be speaking on the topic of recontextualizing the LLB curriculum for an African university, commercial transactions law.
Thank you, Ben. If I could just load my PowerPoint presentation. Here we go. There we go. Okay. So, yeah, South Africa is a country with a difficult history, and we haven't quite managed in many ways to move away from this. And this continues to be difficult in the university space, and the political situation at present is quite tense and has been for a few years, particularly since widespread student protests from 2015. The students called for decolonization, which I'll elaborate on in a moment, and that has led to a bit of a rethink, certainly on my part, not on everyone's part, and not saying that everyone rethought in the same way, or even that what I do constitutes decolonization as considered by the students or anyone else. What I would say I've done is aim for something much more moderate, which is greater inclusivity or diversity in both my materials and perhaps also in the way I teach them. Along the way, I will show how this links to the conference theme of vulnerability. So, vulnerability, I haven't gone with a heavy theory definition. I've gone with something a little bit more practical. So my context of my talk today is, of course, education, legal education, and specifically legal education at the University of Cape Town. So I thought that I would give some practical factors from my own experience and also from various sort of university-wide documents that I've read of what problems might be. So the schooling in South Africa demonstrates a wide range of inequality. So there's high-priced private education or better state schools, typically in urban areas and certain parts of urban areas. And then there's more basic state schools, which will often provide quite a weak educational founding. And that might be where many of our students come from. So not everyone who comes to the University of Cape Town has a good primary and secondary educational grounding. Secondly, the University of Cape Town is an English language university. So instruction is done in English. Not all South Africans have English as the first language. In fact, not even most South Africans do. So if English is your second or your third language, and particularly if it's not particularly that strong, this can be reasons why people might struggle at UCT. And then, of course, the big one is poverty and a lack of access to resources. Students need a quiet place in which to study. Not everyone has that. People need internet connectivity these days. You need a laptop, you need something to work on, and access to that kind of resources can be difficult. Now, UCT cures some of these things by having everyone in residences who might be deemed to be vulnerable, particularly in the above sense. But with COVID, we had a very strict lockdown in 2020, which resulted in everyone being sent home. University instruction went online, and many of the above problems were compounded and exacerbated. Things are opening up again, have been for most of this year, so some of these problems are alleviated, but there are certainly still vulnerabilities in place. Now, of course, the big element for in the room is that in South Africa, we have a high degree of inequality, which due to our history is also a racialized inequality. This is sensitive territory, so I thought I would ask our UCT Office for Inclusivity and Change, which deals with transformation, if they had, a working definition of vulnerability at all that I could use for this talk. They sent the infographic below, produced during COVID last year. It's a useful free resource if anyone's interested in what educational vulnerability might look like in a South African university. What this infographic unsurprisingly highlights is that race can sometimes be a proxy for disadvantage at UCT as well. The gender can sometimes be a proxy for disadvantage, and that things like disability can compound vulnerability, and particularly these factors work in an intersectional way, so that they might together compound each other or combine some of the more neutral features which I've identified above. So this is sort of my working concept of vulnerability, which I think with the infographic ties in with what the university is working on. However, my presentation today is not strictly about vulnerability in this sense. Rather, I want to turn it on its head. So what I've been trying to do in my teaching is rebalance classroom power dynamics through a shift in narrative emphasis. Now, focusing on the fact that decolonization is a political argument and is about power, in many ways also, about racial power, and the students also made it about gender and sexuality and many other things. I wanted to change the way I did things to speak to some different types of life experiences and a more diverse kind of audience. And I think just to sort of put the conclusion first, that the things I'm about to describe are working in the sense that course reviews have been pretty good, better than they were before since I've started doing this, and that on the whole, these changes have been well received. So to give some broader context, what were the student protests about? From 2015, and at our university, it started with the hashtag Rhodes Must Fall protest. You see there a nice photo of UCT Upper Campus. You see a plastic statue that was a statue of Cecil John Rhodes, the notorious colonialist. Stood at UCT from the 1920s until 2015 when it was taken down. You might wonder why we would have a colonialist on our grounds. The reason was that he donated the land on the slopes of Table Mountain on which the University of Cape Town currently stands. Nevertheless, student protests saw that being taken down in what, for university council terms, was a very swift period of time. Later that year, 2016, later 2015, 2016, 2017, the protests spread to all universities. Might be a little bit egocentric to say it started at UCT, but certainly by the end of 2015, there were all universities in South Africa, nationwide shutdown of universities. Then it was about student fees, that fees were too high. So state funding of South African universities doesn't necessarily cover everyone's costs. Fees have been high. They've been increasing above inflationary terms. And the student protests were about capping the fees and stopping that rise. And they also had other arguments like decolonization, as I've highlighted. They said that historically white universities, which would include UCT, were far too Eurocentric in their approach, which of course requires, I think, when most of the law that is taught, other than the course on African customary law, focuses on received law that comes largely from European sources. So if you look at things that our constitutional court is saying, obviously in far less radical and tones, this is a case on contract. It says the development of our economy and contract law has thus far predominantly been shaped by the colonial legal tradition represented by English law, Roman law, and Roman Dutch law. Now, of course, that's fully correct. South African common law of contract, we're a mixed legal system, and those are the sources, ignoring maybe statutory law, particularly statutory consumer law, and changes that are happening as a result of the constitutional impact on contract law in the democratic era. That's fair comment. And taking that as a call combined with sort of the motivation provided by student protests and the call for change, I've in my own research asked, what is African about contracting? Is there a customary law of commercial activity of contracting? And that's been quite a productive line for me. That's a different presentation though. Today, briefly in the time left, I want to talk about how does the South African commercial law teacher respond to the challenge that the subject is alien, unrelatable, and mostly for rich people. Now, of course, one needs commercial law. If you're going to practice for a big law firm, that's mostly what you're going to be doing. But I also wanted to bring it home and make it feel more comfortable so that you learn either stuff that was useful in a blue chip corporate context, or that you could learn it maybe in a slightly different context, but which could be transposed into that corporate commercial context if needed. This is a case study, as I said, of my LLB course. So, as I've said several times, the students demand decolonization, and this has become a bit of a fashionable catchword in South Africa. It's been heard at national government level, so various bodies that review universities have started throwing it out in policy documents. University management at almost all universities has started turning this word out. We're told that we should be thinking about decolonizing our particular course. But what does this mean, right? If your course is commercial transaction law, it deals mostly with commercial contracts, with risk management, with insolvency. How do you decolonize that? So right away in 2015, I thought I would get ahead of the curve on this. And we've got a platform where you can email all the students in the class. And I said, what do you want? What does decolonization mean for this course? And a wide variety of responses were received, all of which were constructive, and which I summarized into people wanting more indigenous, or specifically African content, more comparative law in Africa, and more social justice topics. Whether that per se constitutes decolonization, I'm not sure. What I have called it and what I've done is recontextualization, specifically for diversity and inclusivity purposes. And yeah, it's different to what the students were asking for, but as I started with, it's gone down well so far. So a little bit more about the course. You see the modules on the right-hand side. We teach the seemingly discrete modules and then show how they all interconnect, particularly with problems in exams and assessments. So I teach the ones in bold: insurance agency, secure transactions, consumer credit. Some of those have been collapsed because we've got to cut down on people's available time now in the remote environment. And you'll see also that most of those modules that I teach are fairly financial. So the course is quite big. It's 190 students this year. Normally it's about 150 to 200 in recent times. 2 course presenters. I do the bold ones. Someone else does the first 3. 72 lectures, 6 small group teaching sessions, mid-year test, final exam, and a voluntary assignment which can reduce the weighting of your final exam should you choose to do it. Now, specifically with regard to just a snapshot of a few things in the syllabus, what I'm aiming for, as I said just now, is relatable commercial law, which of course, you still need the proper stuff for practice, and I still teach law, and I still teach principles which will help you in practice if you come across secure transactions or you want to know what insolvency is. But yeah, I aim for something which also speaks to other contexts. So maybe it's a small business context. So there's a lot of consumer law. So maybe we can look at an individual context, or maybe we can even look at a vernacular informal economy type context, which is admittedly not much of the lived experience of our fairly middle class students at UCT, even the poorer ones. But maybe, this is something that people should learn about, even particularly very middle class students who went to a private school and are maybe not from that particular ethnic group. So in the law, with regard to, consumer law and the law of individuals, we've got a big module on consumer credit, look at things like the costs of credit, reckless lending, how that controls access to credit, how the cost of credit is often greater for people who are less well-resourced and for people who are better less resourced, of course, for commercially justifiable reasons like risk and security, but it's still a factor. We look at debt review and over-indebtedness. Debt is a big theme, and how debt review, you still have to be able to pay off your debts in full in order to do that, plus the debt counselor's fees. It's a private system. The only way you can absolve your debts is through the to the Insolvency Act, but then you need quite a big estate to pay for High Court applications and a trustee. So now we've got a new system under amendments in 2019 to the Consumer Credit Statute, not yet in force and very controversial, but it's a way in which no income, no asset debtors can have their debts extinguished. We look at debt execution, both with movable property without recourse to a court, which is an interesting private law area, bit of contract drafting and nitty-gritty to look at there. But then also, bringing in the constitutional, bringing social justice issues like the right to housing, right to adequate housing, which is a socio-economic right under the South African Constitution. Residential mortgage foreclosure. It used to be, a very easy process to get in years gone by. Now has become far more complicated since about 2011 or mid 2000s even in South Africa. There's new law on this. There's new procedural rules that practitioners have to follow when doing this. And we look at how this links through the case law to the right to housing and what you have to do exactly if you want to sell someone's home. In the insurance module, we look at microinsurance. Well, we look at the core principles of insurance. This year I did business interruption insurance linking to the whole COVID saga, which again is interesting because it's close to things that are happening in people's lives. But from a transformative angle, we look at microinsurance, which is ensuring low-cost risks for typically less wealthy people, insurtech and the role it can play in increasing access to insurance. And of course, this is from the legal angle and what is the new law on this. The theme of my financial modules is inclusion. And you can bring in...
Yeah, if possible, please.
Okay, super quick. So from an inclusion aspect with financial inclusion, it's not just giving everyone a bank account and access to safe and affordable credit insurance, but also, you can bring in the informal vernacular economy here with the savings and credit clubs, the so-called WASPs in anthropology literature. And this is research-led teaching that I've done my own empirical work on this. And then, of course, fintech, things like mobile money I've covered in some years. So I would argue that this commercial transactions law is of relevance to everyone, whether you're a blue chip practitioner or even just a normal member of the economy. It can help you in your everyday life. One thing we can improve on is experiential learning. We see an example of this in the bottom of the slide, which is a student-led consultancy sending lawyers, accountants, economists, similar people into township areas to help small businesses improve their offering. The last slide that I'll leave you on is just an advert for some of my own work. I'll stop there.
Fantastic. Thank you very much, Andrew. And as Christine says, some great tips there for teaching. And if anyone has any comments or questions, please feel free to add those to the chat. But before we get to our question and answer part, it's my pleasure to now welcome our final speaker, Professor Kirpichev. Alexander will be speaking on the topic of a study of vulnerability in decisions of courts of post-socialist countries on consumer protection cases, explicit or implicit, individual or collective. Over to you, Alexander.
Thank you so much. I hope that you can hear me now and you'll see my presentation on your screens. Can you hear me? Yeah, thank you, Ben.
Yeah, I can hear you and see. Thank you.
Thank you. So I hope that the collected data will be helpful or even useful for further researchers. So following minutes, I will try to present it and explain its value. You certainly may ask, why do we need to study the vulnerability in these legal systems now? The answer is clear. Because I'm going to make the vulnerability doctrine known, at least in the Russian-speaking legal community, and who knows, it may become too popular. Therefore, I decided to organize this study before my or others' overviews of the vulnerability theory are published. Actually, I often work with judges and court decisions, so for me, the mutual influence of legal doctrine and adjudication is very important. I began this research by reading numerous decisions from post-socialist countries And that reading helped me to acquire some ideas. First of all, in most of non-European Union post-socialist countries, we don't have the terms vulnerability or vulnerable in our positive law. But as you can see from the charts, sometimes our courts do refer to these concepts. Don't worry, I am not going to read all the numbers allowed in any language. I know that sounds very difficult. You can see the same statistics for Ukraine on the next slide, the Ukraine flag, but the only firm conclusion we can make from the charts is that courts refer to the concept. There is a study that researchers have a reasonable limit. We usually don't know what a judge really thinks about the case, and we don't know whether they implicitly refer to the concept of vulnerability. That made me explore this subject on a different level, but again with the empirical method. As I mentioned before, I read a lot of decisions in many languages I can read in. So in this part, I studied 5 examples where, in my opinion, the vulnerability is a part of a key legal issue. So the first case is about a young man who visited a shopping mall where a bank clerk offered him a loan or credit. So most of the text of the credit agreement referred to the terms on the website. Due to his youth, the young man didn't understand the full interest rate, or the full rate, full price of credit. He simply didn't calculate it. In my domestic legal system, such a situation is prevented already by public regulation. So this case is all the more interesting for me as the Ukrainian court assessed it. So, the Ukrainian court ruled that the young man is a more vulnerable subject than an ordinary consumer and declared the contract invalid. The court, ordinary district court, not a Supreme Court, even mentioned the unknown for the positive law of Ukraine term vulnerable. So let's move on. The next case is from Czech Republic, a country that have much more independent legal theory history than many other post-socialist countries. The fact was that a couple of tourists arrived to check in at the Czech hotel. The owner, having learned that the tourists had, as I do, Russian passports, he demanded that they write a declaration that they personally recognize the Crimea as a part of Ukraine. The tourists refused and called the police, believing that they were unreasonably denied services and being discriminated against by the requirement to declare, openly declare their political position. The hotel was firstly fined by the police, but in the end, the Czech Constitutional Court recognized that there was no discrimination since there were other hotels in the city, and the position that they were asked to declare corresponds to the official position of the Ministry of Foreign Affairs of the Czech Republic. The dissenting opinion of one of the judges and comments on the press raises a natural question. Would the decision have changed if it were the only hotel in the city or in the area of the city or in a block in the city? The next studied case is from another part of Eurasia. Have you heard about Kirpichev Republic? A woman had found that a large sum of money was written off her bank card account. Like she bought something on a foreign internet site she had never visited. In court proceedings, the bank refused to return the money, although she had applied to dispute the transaction on the same day. The bank explained to court that the transaction had gone through famous fraudulent, scam, I'm not sure, website. From the bank's point of view, the information that was a criminal website should have absolved the bank of responsibility, free from responsibility. However, the court decided otherwise. Since the bank has previously encountered fraud through this site, the bank could take some actions to prevent the situation. Here, the consumer was recognized as vulnerable. Unlike the bank, the consumer couldn't take action in advance. On the next slide, we see the fourth decision. The story. So, in 1990, I'm sorry, in 2020, the Russian government adopts a decree on a matter to return of money paid to tourists who would not go on vacation due to the pandemic. In this case, the state helps vulnerable travel agencies, not consumers. The decree came into force on July 24, and as a general rule, tourists must receive their money back by December 31 this year. However, there are 4 exceptions: aged people, disabled persons, retired persons, unemployed. At the same time, the decree, not provided by Parliament law, decree said that this situation, this hardship, should come during the period of the decree. So its commands, its begin should be after July of last year. Then, if a person was disabled before the date of the decree came into force, according to literal interpretation, such person is not valuable. I'm sorry, I'm so nervous on this point, because later the Supreme Court of Russia prevented such a literal interpretation and used a teleological, I hope that this is the correct term, for interpretation with understanding of the aim of the legislator. So the decree, according to the court, protects all vulnerable if at least one day after July they were in the named situation. I understand that this is a predictable interpretation for many legal systems, but here in Eastern Europe, or even far, legal positivism significantly dominates, and therefore a literal interpretation is predominantly used by courts. The second and the most important part of my study and my presentation, thank you for remaining about time, is another way of empirical study. I organized an anonymous poll or survey and asked many judges to respond to it anonymously. Currently, I collected 17 opinions. So first of all, I want to learn their ideology, and later some issues on vulnerable consumer. I will not read aloud, of course, all these slides. One of the most favorite expression of Karl Marx, surprisingly for me, is not a commonplace for Russian judges. As well, the thoughts of Professor Pashukanis, founder of Marxist legal theory, are closer, but they do not completely read him. So as we know from works of Martha Feynman, we know, the vulnerable subject competes with the concept of liberal subject. Judges do think that they do believe in liberal independent subject. But let's move on. They also agree with a statement borrowed by me from, or a quote borrowed by me from one of the articles of Martha Feynman. I suppose you know this quote better than I do. And later, I began questioning them about vulnerability. So they agree on value of vulnerability. I know that there are maybe 2 minutes left for me, but as the common place and the common point, they are not ready to recognize a corporation as a the vulnerable party in consumer case. But there is an exception. When a consumer submits a lot of the same type lawsuits, that courts, that judges, in that case, judges anonymously answer that seller business is vulnerable. Then I ask them whether they agree with the decision of the Ukrainian court. I hope that despite of all these charts, you still remain, you still remember. Oh, it's terrible. You still remember what happened in this case. I'm sorry. And the last thing I asked them. Oh, now you see. The Russian Civil Code. I'm not sure that this is a good translation. It's not mine. Has a traditional rule, traditional from Roman law, from Diocletian. It's usually called reductio ad equitatem, that a court may reduce amount of forfeit in certain circumstances. But I asked judges, can the forfeit be reduced in another, I didn't type it, in a situation when a consumer is just in a hardship, in a hard living situation? This is not permitted by positive law. This is not permitted by Supreme Court, but the answer is yes. So I have to finish, and as a conclusion, I want to invite you to our legal scholarship event on November. You can find call for papers. Thank you very much.
Fantastic. Thank you very much, Alexander. Thank you very much once again to all of our speakers who are welcome to put their cameras on again should they wish. So if anyone has any questions, please do feel free to raise your hands or to add those to the chat. I see that there's one question in the chat already, a small question, a simple question, directed to Alexander, asking whether you will publish this research in English, in the English language, so that many of us can benefit from your findings.
Well, first of all, I suppose that you may refer to the data on YouTube when it will be published, that video. And of course, I'm going to finish the paper and transformate it into an article, but I'm not sure about the good journal to publish in? You may give me an advice.
Well, I'm sure that Christine could definitely advise. I agree with what Christine says, that it's terrific to get more information and more insights from this part of the world, because for many of us who unfortunately don't speak more than one language, I'm including myself in that, we really rely upon those of you who are able to share insights from jurisdictions where English is not the language of judgment. So thank you, Alexander. There is a question in the chat for Eleni. I'm not sure if you can see it. I'll read it out just while you're thinking. I'll read it out just while you're thinking. So
okay.
It states that it interests, Lice is interested in Eleni's perception on how this better framework should be constructed. Do you, Eleni, think contractual law in the future will work with more differences according to groups of people, or maybe with generalizations, general clauses, as usually happens?
Well, thank you, Lice, for the question, and I hope we'll hear more from Lice tomorrow in her presentation. Well, there is here, we need to make the distinction between theory and practice. And as we said, in theory, we can talk about universality of vulnerability, and how we all experience vulnerability, and that is a very useful message to hang on to also into our law. But we also need to be practical, and in practice, regulators will always want to pick out certain categories of consumers that they believe need more help. I suggest that the way to do that, at least from a consumer law perspective, is to combine the two approaches. So that's why I said we can have a definition that is more general and more flexible in terms of these dimensions of vulnerability and the factors that come in to increasing someone's vulnerability or increasing their resilience on the other hand, and kind of creating that balance. And then legislators are free to also have sectoral pieces of legislation which may be useful in specific contexts. And we already have that, like that might be the digital environment, like I just mentioned, but it can also be things like energy, utilities, financial services, where they may want to focus on a more specific set of criteria or a definition that is more specific to the circumstances of that area. But the two of them, I think it's best to coexist. And going even further than that, you can have guidance documents, soft law documents, where again, regulators can be even more prescriptive about the real life challenges that they are facing and how to best adapt the general framework to that. So I would go for this kind of layered approach. I hope that answers the question.
Yeah, that's really insightful. Thank you very much, Eleni. And really, really great as well as focusing our attention on that question of how we actually understand or how we define vulnerability, which I know is something, a thread that goes throughout the entirety of this conference. I have quite a broad question, if I may, for Andrew, if you don't mind. Just out of interest, really, and I guess as a fellow academic, much of what you were talking about resonates with what we've seen here in the UK as well. And I'm just wondering to what extent what the student response has been, I guess, to the real efforts that it's evident that you're putting into decolonizing or recontextualizing your curriculum, and I guess what the student response has been so far to that.
Thanks, Ben. Thanks. Yeah, I would say it's been good on the whole. I mean, I think it's a complex question to answer in that what I'm doing will definitely not be good enough for example, the core student protesters, because it's just not radical enough. It's not focused on core sort of critical theory enough. But I think also that group of sort of radical core protesters is a minority. And most people, when I say most, I mean the majority of people, which of course cuts across races, were more focused on getting on with it and wanting to get back in class and study during the protest years. And a lot of those people, you know, are definitely more in sort of the South African constitutional mold of inclusivity, of diversity, of centre left. And I think people appreciate that I have made an effort in the way, you know, making an effort helps in the way that a lot of lecturers are quite, stuck in the way they do things and refuse to change. But I mean, some of us are changing in different ways. But what I can say is that I've had a lot of positive feedback, both in person when we were in person and via email and in, the course reviews that we do at the end of courses. And it's certainly, I think that kind of feedback has got a lot better than it was, in prior years, prior to 2015.
That's great. Thank you, Andrew. And it'd be interesting to hear going forward, the continuing evolution of this, the advances, and also the student response as well. Rawia, I believe you've got your hand up if you would like to unmute and show your face.
Hi, thank you, Ben. Thank you, Andrew, for your presentation. My question was directed to the study you conducted, which sounded really fascinating. And it was about when you said students demanded decolonization in terms of that social justice perspective as well. And I just wondered whether you could expand on what they said and how you incorporated those sorts of topics into your particular module, and whether you thought that perhaps those social justice questions would have been better answered in different modules, and whether that's what students were after as well. Thank you.
Thank you, Rawia, for that question. Yeah, so the social justice is very much in vogue in South Africa. So I know that people know a bit about South African law normally when I speak, but we've got this transformative constitution. And there's this process called transformative constitutionalism, which kind of feeds into everything, and being the supreme law and having wide horizontal reach into private law and everything. It kind of cuts across sectors. So even in core areas of commercial law, certainly in the law of contract, there's a lot of talk about, what the Constitution requires, whether it requires some sort of positive duties between people. Certainly once you get into like the law of credit, I mentioned the right to housing, which has been relevant when you're trying to evict someone from their home, but also more generally about whether people have a right of access to a court. So you can't, for example, execute without recourse to a court, and a lot of emphasis on fair processes and that sort of thing. Yeah. So I mean, I think to the extent that social justice comes out, it's something that people do want, and that they do want to hear it in all their courses. But South African law being the way there is, and our constitutional court being the kind of institution that is, that here's the kind of cases that it does. Here's a lot of sort of pro-poor type cases from vulnerable type low-income people in marginal situations that this law feeds through. So like, for example, in the property law course, there's lots of things you can talk about there, whether it's evictions or, redistribution of land, constitutional law. There's all kinds of cases. Almost every subject you can find this, even in the subject on commercial law, like my own. So I think this is something we talk about. I think that this is really core to what is fashionable and what people talk about in South African universities.
Brilliant. Thank you. Thank you for that answer, Andrew.
Thank you, Rawia. And like a flash, I think we're already at the end of our time. That was a fantastic panel, 3 really fantastic discussions, presentations and discussions. If anyone has any questions, then of course tomorrow you've got a full day of further panels and chances, no doubt, for further discussion. I see that I think Christine has put a note in the chat about what's to come tomorrow. But from me, at least, I just want to say thank you so much once again to all of our speakers, to everyone who contributed to the discussion, and I wish you all a wonderful evening.
Thank you, Ben. Thank you very much.
Thank you.
As well. See you tomorrow at 10 o'clock.
Thank you, everyone. Bye.